hands off me and two, uncuff me.
No, I don't want to tell him anything.
Okay.
You'll wait till a supervisor gets here, and you can talk to him from there, okay?
Right, I'm done talking to you guys then.
Okay.
So what's up?
He's taking pictures of the department, taking pictures of all our stuff here, so I don't know what he's doing. Try to talk to him, he's not talking to me, he starts walking away.
Is that a reason to cuff me?
Yeah, you're being detained right now. Yeah.
For what? For what crime?
Yeah, no, it's reasonable suspicion.
Of what crime?
Okay.
You have to have reasonable suspicion of a...
Before we even roll this footage, let's set the stage, because what you're about to watch isn't just another sidewalk encounter. This is a classic clash between a citizen asserting constitutional rights and officers who may or may not fully understand where their authority begins, and where it absolutely ends. A man stands outside a police department, camera in hand, doing something that courts across the United States have repeatedly ruled is protected by the First Amendment, recording in public. But within moments, tension rises, questions turn into commands, and commands turn into cuffs. The real question isn't just what happened, it's why it escalated so fast. Was this a misunderstanding, a power trip, or simply a lack of training? And more importantly, what happens when someone exercises a right that makes authorities uncomfortable? Stay with us, because every second of this interaction matters, and by the end of this video, you'll have to decide for yourself, was this lawful policing, or a costly mistake in the making?
A crime to detain somebody.
I am not going to speak to you.
That's
you can
fine.
speak to my supervisor when he gets here.
You have me in cuffs right now.
Okay, yeah. You're
So I'm
being
gonna
detained
talk-
at the moment, yeah.
Because you're an asshole. That's
Okay. What's that? So I'm loading up. I'm loading up. This guy's on the corner. I thought he was taking a picture of the eagle on the department. He's like, oh, okay, no big deal. So I start, putting myself in my patrol vehicle. So he walks past it, and I was like, oh, he's leaving. Can you answer?
Can't talk right now, I'm busy.
So he starts walking, so I back up, and then he's next to this corner now taking pictures. I'm like, what is he doing? So then he comes over, he starts taking pictures. Oh, it looks like he's taking pictures of these signs. I don't know if he's taking pictures of these cars or what.
You can feel the tone shift from casual curiosity to confrontation. Notice how the officer moves quickly from a greeting to a demand for identification and explanation. Now here's the key legal tension. In many jurisdictions, simply taking pictures from a public sidewalk does not create reasonable suspicion of a crime. Yet the expectation from the officer seems to be immediate compliance and conversation. This is where many encounters go sideways, not because a crime occurred, but because silence or refusal to engage is interpreted as suspicious. But is choosing not to answer questions actually grounds for detention? Courts have repeatedly weighed in on this issue, and the line between a consensual encounter and an unlawful detention can hinge on just a few seconds of behavior. Watch closely, because what happens next will determine whether this stays a conversation, or becomes a constitutional problem.
It's an organization called the First Amendment Strike Team.
Is he?
Yeah,
Okay.
so he's trying to see what we're going to do.
Okay.
He has every right to do that.
Okay, and that's fine with that. I don't have an issue.
Uncuff him.
I like
Uncuff him,
calling against this officer right now.
Uncuff him.
Because I did nothing wrong. I was not breaking the law, and this officer just legally detained me under CRS 16-103.
I've seen your video, sir, and I know
Okay.
exactly what you're talking about.
Who am I?
First Amendment Strike Team.
Okay,
I know exactly who you are.
exactly.
Um,
So you know I'm not out here doing anything illegal.
I do.
No, nothing.
I do.
And I'd like to file a complaint against this officer for
There's two-
deprivation of rights.
You can actually go into the department.
Okay.
File the complaint if you'd like to. Should have caught you before. I understand totally what you're doing.
So will you be suspended administratively until the thing is cleared out?
No.
He just broke the law.
I understand
He
that.
should be
There'll
arrested.
So an internal affairs investigation.
And just like that, the situation escalates into handcuffs. This is the pivotal moment. The officer openly states that taking pictures of the police department could justify cuffs, which raises a serious legal question: what specific crime is being suspected? The man immediately claims illegal detention, citing statute, and requests a supervisor, a move often recommended by civil rights attorneys when disputes arise. What's fascinating here is how quickly authority becomes a tug-of-war. The officer asserts control, the citizen asserts rights. But in court, it won't be about tone or attitude, it will be about articulable suspicion. Could the officer clearly explain a crime in progress? Or will this be seen as detaining someone simply for not answering questions? The difference between those two scenarios can mean everything, including lawsuits, disciplinary action, and
If you want to file a complaint, will be conducted, and depending on the findings of that, it'll be dealt with depending on what.
So is there going to be any issue with me getting his body cam information?
That you would have to go through our records division.
Yep.
I'm not sure how that works.
Hey guys, call Pueblo Police Department and complain about Officer Romero, badge number 0707. He just detained me and said that he was detaining me because I chose not to answer his questions.
I'm not really sure on how that works. I have to look at the policy on that.
Commentary in the original video hints at the bigger picture, how these street encounters translate into courtroom scrutiny. Because here's the reality, officers don't just have to justify actions on the sidewalk, they have to justify them under oath. Judges look for clear, objective reasoning. Was there a threat? A report of a crime? Suspicious behavior beyond simply recording? If the answer is no, then detaining someone can become legally indefensible. And when cases like this reach civil court, they often hinge on whether the officer had a lawful basis to escalate. Viewers at home might see a tense interaction, but attorneys see potential liability. This is why training and understanding of First Amendment rights are critical. One misstep can cost not only credibility, but also thousands of dollars in settlements paid by the public.
I believe that there's a charge. Here's Sergeant Reyes, he's the supervisor on the watch commander, and he might know. I'm not sure how that works. Actually, I can make a phone call and find out.
I think I'd appreciate it.
Thank you.
You're good. I'm gonna go home now.
Yeah, you can go home.
Tyrant Romero, badge 0702.
Yes, Captain Martin needs to speak to you. So I don't know if they even need me here anymore, so.
Is there a charge? Okay. Do you know what the charge is? Okay, I'll find out.
Chose not to answer his questions.
Notice the shift now that identification is requested. The citizen asks for name and badge number, something that is typically required of officers in many departments. This moment often resets the tone, because once documentation starts, accountability enters the picture. But we're also seeing a familiar pattern, waiting for a supervisor. Supervisors often serve as the reset button in tense encounters, especially when legal gray areas appear. The question is whether the supervisor will double down on the detention or correct course. And this is where departments either prevent lawsuits or walk straight into them. Because if a supervisor recognizes there's no lawful basis for detention, the smart move is immediate release. If not, the risk multiplies. The clock is ticking, and every minute someone is detained without
Grab him by the arm.
Okay. 30 seconds. Yeah, he's asking questions. I'm not sure. This is that guy.
Sergeant Reyes here.
How are you, sir?
Could be doing better. Doing better now. I actually like this officer charge.
What plays 4K on your camera? What plays 4K? I know like the TVs do, but how do you edit 4K?
Computers do also, and all the software editing stuff is all 4K compatible. So even if your computer isn't, you can upload it or fix it. I can go inside stuff.
Let me call records real quick. There, you have to submit a Freedom of Information Act for the body cam video. There's a charge. I'm not sure what the charge is, but I'm going to find out.
the officer's explanation. From his perspective, he saw someone taking pictures, walking away when approached, and continuing to record vehicles and signage. But here's the critical issue: is that behavior criminal or merely unusual? Courts have consistently ruled that unusual does not equal illegal. Officers are trained to investigate suspicious activity, yes, but investigations must remain consensual unless there's reasonable suspicion of a crime. Walking away from police and refusing conversation is generally protected behavior. So the officer's narrative may explain his concern, but concern alone doesn't automatically justify detention. This is where the legal microscope zooms in. Could he articulate a specific law being violated? If not, the detention could be ruled unlawful, even if the officer believed he was acting cautiously. Intent and legality don't always align.